The next case on the docket is Memorial Hospital versus News-Journal Corporation.
Please, the court. My name is Arthur England. On behalf of Memorial Hospital, I would like Mr. Farmer to reserve 5 minutes. I'll try to remember that myself. Your Honors, I don't intend to spend any time today addressing the cross-appeal issue presented by Mr. Andrews as to whether the sale of Memorial Hospital to Adventist was invalid because out of the sunshine we think it was made in the sunshine and cured, and I'll rely on our briefs for that. But I want to use my time to address the trial court's holding that there's no difference between a lease of a hospital facility from a public authority and the sale of those facilities to a private corporation. And the second part, that the Florida Supreme Court's decision in Memorial Hospital, affirming your decision in the same case, does not require a Schwab factor analysis because there was a delegation of a public function. I think the arguments set out in the briefs are really adequate to address the point, and I want to focus the court on, use this time to focus the court on a couple aspects of it that I think are determinative. Because this is the first case in the state of Florida in which any appellate court has considered the statute enacted in 1996, which allows a sale of a hospital from a governmental agency or authority to a private entity. Now, you recall in the briefs, the News Journal insists that it required a statute to allow this sale. Take that as a given. And here, that leads to, the News Journal's argument, Mr. Andrews' argument, leads to two completely untenable, I respectfully suggest, and prohibited conclusions. First, their position requires you to hold that the 1996 statute is meaningless, that it is an absolutely useless act by the legislature which has no purpose and no utility. And I say that because the statute we're talking about is the amendment to Section 155.40 that was enacted by Chapter 96, 304, Laws of Florida. And I mention that because this is more important to look at, the Laws of Florida provision in which it was enacted, than the Florida statutes where you normally see it, because this shows the changes that were made. And this 1996 enactment in Section 1 added the authority of governmental agencies to sell, which was already existent as to leases, requiring only that it be in the best interest of the public. That was Section 1. The only other section of this particular statute that is relevant is Section 4, which says the sale has to be at fair market value. Why is that important? It's important because the position that you're hearing from the appellees is the statute has no validity. There is no difference between a lease and a sale. And what the legislature did is a useless act. You know the law is that you can never presume, you can never interpret a statute to be completely non-utilitarian.
But Mr. England, if there was a reverter clause there or some requirements that they operate this hospital in a certain way, then that would still tie this hospital back, wouldn't it?
There is no reverter clause, Your Honor.
I said if.
I'm sorry, if there was?
If there were. And isn't there a 20-year covenant that your client has undertaken to perform? Absolutely. Would that be sufficient to make this delegation argument valid?
No. What the appellees are saying, Your Honors, is that it doesn't matter that there was a sale. In fact, the News Journal brief says this quite so. Oh, a technical aspect of a sale, but it's just like a lease, and you're entitled to treat it as if the two are exactly the same. But my point, Judge Sharp, is that that means the legislature did not accomplish anything when it added the authority to sell.
Well, I agree with your position, but I'm saying, aren't there some connections here that may tie this hospital back to the authority, at least for the 20 years?
Right, and that would require a Schwab factor analysis.
Yes.
That's exactly our point. And they say, and the trial court held, we're not going to do a Schwab factor analysis. It's not necessary. And that's our problem with it. By the way, I have to tell you that today I filed a notice of supplemental authority, gave counsel a copy just for the point that you can't interpret a statute to do a useless act. You know that proposition, but I wanted you to have something in front of you.
So your position is that the Schwab factor should have been factored in here, and not a delegation analysis.
That's correct, Your Honor. That's correct.
Can you summarize for us some of the conditions of this sale that are other than a straight sale? What kind of conditions the hospital placed on it that would make this different from other sales, and how should that be weighed in a Schwab factor?
Well, I've gone through that in my brief, and I think I'm going to rely on that for saying that the Schwab factors come out in terms of this not being subject to public scrutiny. But the factors that include the name has to be retained, there have to be so many beds, there has to be a medical staff composed of such and such. In other words, to continue the public purpose, and it recites that also, of serving the public, indigent care under contract. But the point is, we don't get to a Schwab factor analysis according to the appellees because nothing changed. That's exactly their position. As I say, that disregards the principle that the statute has to be given some meaning, but it disregards something else which is possibly equally important. It disregards what the Florida Supreme Court said in the Memorial Hospital case, in which they rely on, which we all rely. I take you back to New York Times versus PAH Mental Health in 93, where the Florida Supreme Court said, and I quote, private entities should look to the factors in Schwab to determine their possible agency status under Chapter 119, unquote. 6 years later, in the Memorial Hospital decision, the Florida Supreme Court said again, and I quote, we continue to recognize the difficulty inherent in making a determination whether a private actor is acting on behalf of a public agency, unquote. Then it says, quote, and state that private entities should look to the factors announced in Schwab to determine their agency status, unquote. Now, this is the same court saying that at the time it was considering a legislative enactment in 1998 that said in its introductory statements of intent, there's a lot of problem with private entities knowing whether they're subject to the public records law, and therefore we enact the statute which created the 98 statute that's been held constitutional, Section 395.3036. So here is the court saying, we know there's a difficulty. We've got to give a test. Look to the Schwab factors. The trial court ignored that instruction. Appellees would have you ignore that instruction. And remember this that the Florida Supreme Court said in Memorial Hospital also to cap the point. Public scrutiny of these assets, and that was meaning the assets belong to the hospital, should continue as long as the authority owns these assets, unquote. Appellees would write that out. They would say the Supreme Court doesn't mean that because, well, just because ownership changed doesn't matter. That can't be the test. There has to be an evaluation of the kinds of things that concern Your Honors. A Schwab factor analysis. That's what Schwab was about, Memorial Hospital was about. There is no separate delegation of authority. We can look in the abstract without considering factors and just decide. But there's another concern with their test, this test of, well, they call it totality of factors test. Delegation, totality of factors, those are interchangeable terms in their brief. Nowhere is it explained how you can have a totality of factors, plural, without telling us what those factors are. We know the factors are the ones from the Schwab decision, the ones adopted in Memorial Hospital, the ones your court used in the Memorial case. What factors would you totalize if there were only one? We know delegation was considered in two of the factors identified in Schwab, brought forward in Memorial, used by you in the Memorial case. How can there be a consideration of, quote, totality of the factors without analyzing the factors? And how can one of the factors, the all-encompassing one that they want, delegation of a public authority, how can that be the be-all and end-all when it was simply two elements out of 9 factors in the Schwab and Memorial Hospital decision? We think the Florida Supreme Court decision best understood, Memorial Hospital, was relating to the phrase that they used twice in the opinion, that this was a delegation of the operation and maintenance of the hospital. Those are the operative terms. That's the term you used in your memorial decision, which was affirmed, and the factor analysis affirmed, when you say we have to weigh the several factors. You use the word weigh. They say, no, don't weigh, just go on straight delegation. We say the authority here is not operating or maintaining this hospital. Yes, it has some covenants, and it has the right to go into court to see that they're enforced, but it cannot perform the operation or the maintenance, investing no funds. If anything, there has to be a Schwab factor analysis.
Could we do a Schwab factor analysis here?
I think you can, Your Honor. It's very straightforward. We've done it in our brief. I do not think you have to remand. It comes out. There are a couple factors which favor public access, but the predominance, and you will see, is that this has been transferred out of the control of the authority. What happened here, Your Honor, is very simple. The authority was faced with a financial crisis, the very thing, by the way, mentioned in the statutory statement of intent in the 98 statute by the legislature that led it to exempt hospitals. And it said, we got to get out of this business. And they affirmatively decided to commit their funds, the taxpayer dollar, to other activities. We've identified that some of those on pages 27 and 28 of our initial brief. They're out of the hospital business there. Yes, there's a hospital. Yes, it serves the public to have a hospital there. And yes, the authority has, as one of its roles, or maybe its only role, providing hospital services. But 1, 2, and 3 don't add up the way they have.
Counsel, what about this argument that they can't really enforce these restrictive covenants effectively without the Sunshine Law? How can you determine whether there's adequate medical staff there without having the Sunshine Law to help you? How can you...
Well, that argument collapses on their contention that they have the authority. The authority has the authority under the covenants to go into court to get an enforcement. That's easy. I think that, as we said in our brief, there isn't anything that can't be determined without getting into the meetings of the board of directors.
So if they suspect that maybe it's not being maintained at the same level, they'd have to file a lawsuit. Someone would have to file a lawsuit and use discovery to prove it?
Not even necessary. I would think that the News Journal could easily go to the authority and say, we think one of these covenants is being violated. There are 120 beds, not 156. Would you check on that for us?
And you really
have no trouble. No, this does not require the News Journal or any other, or Tanner Andrews, to sit in on the meetings of the board or the staff for the business and the operation and maintenance of the hospital, or to get copies of every minute of every meeting that the board, the controlling board, has. Now, I'd like to save the rest of my time for rebuttal.
You have about 7 minutes.
Thank you.
Please the court. I'm John Caney for the News-Journal Corporation. With me at the council table is Heather Vargas, a partner of mine at the Common Call, and Mr. Tanner Andrews, the pro se defendant. And I promised Tanner I would try to save him 12 minutes. So I'll be responsible for looking at it if I have some help.
Counsel, you're familiar with this Sun Sentinel case, I'm sure, and it talks about language and level of involvement by the public agency as sort of a measuring stick. Look at those covenants that are in there and tell us which one of them you think involves a significant level of involvement by the public agency.
Well, Your Honor, the statute begins by saying that the transaction, whether it be a sale or a lease or a management contract, must be for the purpose of operating and maintaining such hospital. That's in the statute. And then the covenants require that the corporation maintain the hospital, which means they have to have this hospital and continue to operate this hospital, that it maintain the capacity that the name, which probably not a material factor, but must maintain the services. The hospital can't discontinue any service without negotiating with the authority. It must take care of the indigent patient, must carry out the statutory mission of caring for the indigent, including complying with the special act that created this authority.
But where is the involvement by the taxing district in the compliance with that?
Well,
I mean,
Your Honor,
I don't see where they're involved at all in that. As long as they're providing indigent care, the taxing district doesn't have to do anything.
Oh, I think they do, Your Honor. I think they have a statutory duty to see that all of these covenants are complied with.
Well, they can monitor them, but they don't actually decide what steps need to be taken to bring them into compliance. For example, if they lost the accreditation of the hospital, if it lost its accreditation, the district could just simply say, you better get it back, and the hospital then Memorial would have to figure out how to go about doing it, what steps to take to do it. I don't see that it would involve any significant level of involvement by the taxing district to get it back.
Well, Your Honor, that case, Sun Sentinel, and the totality of factors case standard, is in the context of an architectural firm.
I realize that. It's
designing a school.
Yeah.
The distinction I would make here is this would be where the Broward County School Board would have created a charter school to carry out its education mission. And it's accepted by everybody I know that the charter schools, including the Attorney General, are subject to the Sunshine Law. This is more like a charter school than an architectural firm. And so the thing about the totality of factors is they're highly contextual. So the court did mention the significant level of involvement for the purpose of saying that the school board is sitting there reviewing the work product of the architect. They're not telling the architect how to design the building. Well, I don't know how portable that concept is when we come over to the context of this case. What we've said, and I've been ridiculed by my learned friend here for using the elephant analogy, but the significant involvement is a piece of the elephant. But the telos of the test is to figure out if what Justice Wells said, then Chief Justice Wells said, is whether the essential statutory function has been transferred and delegated. So you look at all those pieces and parts of the factors seeking that ultimate answer. When and the analysis of the factors in the Schwab case or the Sun Sentinel case, as well as in the Memorial case in the Supreme Court, as well as this court, the analysis is oriented toward the obvious fact that there was no delegation of anything to an architect firm, and there is a delegation of the operation and maintenance of this statutory hospital.
But you've got a sale, though, where you've got an entirely different entity that can make all of the business decisions on how to operate the hospital, what to charge patients, all of those factors. The district has absolutely nothing to say about that so long as the restrictive covenants, or whatever you want to call them, are complied with.
Well, Your Honor, let me say bundle of sticks in regard to the sale.
Okay.
The sale, to say that it has been sold, if we imply that some sort of lock-in exclusivity of property right has been acquired, we're wrong. They don't have very many sticks at all. That's why I say the distinction between what they could do with the lease versus how many sticks they had under the lease, which is an estate for years, versus the...
Well, the big difference is the lease could be terminated and the property would revert to the district, whereas with a sale, the title is passed to the Memorial Hospital nonprofit corporation. That's a pretty big difference in my view.
Well, Your Honor, I would argue to you, if we had to deal with that case, that among the equitable remedies would be rescission. They assumed and agreed to carry out the statutory mission. They did not put the reverter in, and I've chosen not to make an issue of that because I don't think that's the important.
They did have a right to purchase or something.
The hospital has the first refusal.
If they put it up for sale. But how do they enforce these restrictions? Can they get it back if it's not carried out?
Well, for example, if the hospital corporation were to choose to create, I don't know, a geriatric center or even maybe a dorm for Stetson students or whatever, I would say that the hospital authority should have the right to rescind this transaction. That's such a breach of First, it's unlawful. The statute says it can only be sold to someone who will operate and maintain the hospital. And so if they, and it's explicit in these covenants, if those covenants were breached, the trial court would have to fashion a remedy. They couldn't say, as they've said in their briefs, oh, well, this is probably not enforceable. Anyway, go ahead and do your conduct. That wouldn't happen. I just can't see that happening in a Florida court. And the distinction between bringing action to enforce the covenant versus bringing an action to enforce the lease under the firefights, I think is immaterial. The hospital authority under the prior lease had to sit around and wait and see if they were complying with the covenants in the lease. And if they determined they were not, their remedy would be in a court to enforce the covenants of the lease, including perhaps a claim that the lease should be terminated for breach.
Would you concede that if there were no restrictive covenants or whatever you want to call them put on the sale, or just an outright sale, you give us X dollars and we give you title and all of this, you wouldn't be standing here now?
Yes, sir, I would. If they really had all the bundle of sticks. It's interesting, I'm not supposed to tell war stories, but...
You say that you would still be standing here even if it was an outright sale?
No, sir. If they had all the sticks, if there were not, first, we have to go back to the statute. They couldn't have lawfully made that transaction. But if the statute read differently and said, if you decide you don't want to be in the hospital business anymore, sell the property, shut down, let somebody build something else there, I would have no argument. It is the transfer of the duty to carry out the statutory mission, which I believe makes this...
Could they have sold this for a dormitory?
No, they could not have, because
Under the statute.
The statute only allows the hospital to sell, transfer, or contract for the operation and maintenance of such hospital. And these covenants go very carefully to make sure such hospital, that hospital in the land, continues. They can't reduce the services, they can't reduce the beds, and so forth.
So if you take your argument then to its natural conclusion, there's no way that any public taxing district could sell a hospital or lease a hospital without having the successor entity comply with the Sunshine Law?
Well, there would be, Your Honor. There would be, and that's one of the what do we do next arguments that they've said. The Sunshine Law, there is an exemption for hospitals that are leased in the 98 statute that has been cited to you. Judge Will held that statute unconstitutional in a brilliant ruling, in my opinion, but the first district saw it otherwise, and so by res judicata, they're not a lessee, and I think they agree that the lease exemption doesn't apply to the sale. They couldn't do the other without agreeing with me that there's no difference. But the legislature could authorize these things to be done. It hasn't. What their argument is because the legislature authorized them to sell it, that implies a release from the Sunshine. One thing we know, and Judge Sharp is the author of the Mitchell case, or Michael case, which says we don't imply exemptions to the Sunshine Law in light of the presumption of openness. The whole argument that this statute is useless is that you should infer an implied exemption from what the legislature did with the word sale. They didn't do that. They could pass an exemption. They could also pass a statute, amend 15540, and say, auction it off to the highest bidder for the highest and best use. Forget about health care. That may happen these days the way things are going. But what they did is they handed the ball to this authority. And actually, it's the same corporation, Your Honor. It's actually the same corporation. They changed sole members, but it's the same entity. They changed the deal just slightly, as Judge White.
Does it make any difference if the entity is nonprofit versus private corporation?
Well, the statute authorizes both, but it still requires that the for-profit corporation continue to carry out the statutory mission, operate and maintain the hospital. So I don't see they still couldn't build the condo or the dorm.
If we were to determine that a Schwab test needed to be applied, do you agree that we can apply that test, or does it have to be remanded for the trial court to do that?
Your Honor, a Schwab test, the totality of factors test, I believe that you could apply it, and I think that our argument is that if you apply it, if you apply Schwab, you sustain the ruling, because the test in Schwab is to find this, pardon the metaphor, elephant, and if you go through these, the ones that make a difference to the question of delegation vel non are present. Because of this court's rulings in the Stanfield case, the Putnam County Humane Society case, and the other cases we've cited, which have said that Memorial One in the Supreme Court clarified that we don't have to count factors and worry about the difference between involvement with an architect and involvement with a hospital. If we see that the thing the test is designed to ferret out is present. So if you did count factors and you counted them and weighed them toward the telos of the test, I would say, I agree the court can do it. It's a de novo question of law interpretation of the transaction in light of the statute and cases. But I would say that to isolate them and consider them out of the context of what do they point to? Do they point to delegation? Or are they neutral on delegation? That's what I think Justice Wells meant when he said, however, what we're looking for is the totality of the totalized factor, and that's the delegation. I think I've trespassed on my colleague. If I may, I'll wrap up now. Thank you.
May it please the court, I'm Tanner Andrews, going to discuss not so much what Mr. Caney has said. Everything he said is correct. The form of possessory interest goes to one of the factors that has never, in my research, shown up as a deciding factor. But, Your Honors, we don't have to reach the arguments of learned counsel, because they're all founded on the notion that there was a sale and a purchase and a termination of the lease. And all of those things were done out of the sunshine. The record is clear. There's no dispute that the lease was terminated out of the sunshine and that the decision was made by Memorial. What Memorial has argued is that there's a cure. There's been a cure. And, in fact, the Supreme Court says in Toller, the seminal case, that a cure requires independent, final action in the sunshine. And those are the exact elements that are missing here.
Why doesn't Toller apply to the factual situation in this case?
Well, Toller does apply the rule, Your Honor.
Toller rule, but if you apply it to what actually happened in this case, doesn't Toller exonerate the hospital from the initial violation?
No, Your Honor, because there was never any cure. Memorial decided to terminate the lease, and the authority never had an opportunity to decide whether the lease was terminated. Memorial's termination having been in the shade, as it were, and the authority never having an opportunity to make the decision, they had no opportunity to decide. They obviously couldn't cure. Likewise, where Memorial decided that the authority owed $42 million of public money, that obligation having been triggered, as the hospital concedes, having been triggered by their notice of termination, the authority never had a chance to decide, should they owe $42 million? Is that amount reasonable? Is it correct?
If we agree with your position, what's the remedy?
There are two things that need to happen if you agree with me. First of all, we need to either send it back to the trial court for a declaration or issue a declaration here that says that, in fact, the authority still owns it and that Memorial still has a leasehold interest in it. That is, the lease continues. And secondly, this court needs to affirm the trial court's ruling that the public still enjoy the right of public access to see where their tax money goes.
Well, if it goes back and they then hold a meeting in the public in the sunshine, and haven't they done essentially the same thing as they did when they tried to correct the initial mistake?
Well, they never tried to correct the original mistake in this record. The authority never recognized a mistake because they never had an opportunity, and the lease specifically says when the lease needed to be terminated. That action had to be taken based on a factual situation, had to be taken by the last of March of 2000. Now, if they wanted to somehow retroactively agree to terminate it back then, First, you'd have to modify the lease to allow termination after or on different terms, and I think you'd have to do that in public. And then you'd have to follow through and do what's allowed. And at that point, the public would be able to see where this figure of $42 million that the public allegedly owed, according to Memorial, public could see where this came from and how that decision was reached, if, in fact, the same decision were to be reached again. It's not clear that that decision would be reached again with public input. It's quite likely that if something is done facing public scrutiny, that the public will enjoy a bit more, shall we say, a bit more influence than if they're entirely locked out of the room. Honors, if you have no more questions, I'd like to reserve the last couple of minutes for Sir rebuttal.
You don't get an opportunity to
There's
reserve.
cross.
Oh, there, I'm sorry, you're out of cross field.
You've got 2.5 minutes left for cross field rebuttal.
I'm not going to say very much about the sale. The lease was not terminated by the hospital. It was terminated by the authority at the public meeting, and the sale was cured by the authority. It's pretty straightforward. Mr. Caney's point that equity would support if the authority wanted a rescission. Certainly, rescission is an equitable remedy. Does he really believe that the authority would want to rescind the sale if the bed count dropped from 156 to 145, or the name change, or even if a medical practice dropped out that should have been retained? The authority does not want to get back into the financial bind. It has diverted its tax money to other uses to serve the populace of the community. Rescission is not a realistic remedy and can't expect to happen. You don't have the answer to the question, which is the imponderable here. What could the legislature have been doing, wasting their time, passing this 96 statute to allow a sale if it doesn't mean what we say it means, and if it does mean what they mean? Mr. Caney takes the position, the News-Journal takes the position, that they don't need to go into the Schwab factor analysis because a sale is like a lease. What was the legislature doing? If the lease provision was there, why did they have to say sale? You cannot wipe away that statute. You cannot say it is meaningless. That makes no sense. Caney agrees that you can apply the Schwab factors. We think it comes out quite clearly. He hasn't analyzed them in his brief. We have. Mr. Andrews has given you some take on his view. But after he says that, he comes back to, Mr. Caney comes back to the point he started with. Well, the totality allows you to say that it was a delegation. Again, without the explanation of how you could have a totality of factors when delegation is the only factor. That argument just doesn't fly, and I think you recognize that. Let me go back to where I started. Adventist bought a hospital from a public authority in the belief that the statute in 96 meant something, and in the belief that they would not be subject to the open records law. In Memorial Hospital, the Florida Supreme Court said, we want to give guidance to private entities when they are going to buy or whether they're going to acquire these interests. Look to the Schwab factors, repeating what they had said 6 years before in New York Times. It is quite clear that that requirement of the Schwab factor analysis was built into the Supreme Court's decision when the authority went out of the quote, and I'm quoting from the Memorial Hospital brief, opinion, the operation and maintenance of a hospital. As Judge Boyce, as you said, they're not doing anything at the hospital. They are not operating or maintaining. Adventist did what it thought it was authorized to do. The Supreme Court has told us what the outcome is. It seems to me that the position of the News-Journal is you to disregard the statute and the Supreme Court to come to that conclusion. We suggest you cannot. We respectfully suggest that you end the public scrutiny of Memorial Hospital, West Volusia, There's no need to remand because the factor analysis comes out only one way, as we've demonstrated in our brief, that there is no public scrutiny. We ask that you vacate the final judgment and remand with instructions to enter a summary judgment for Memorial Hospital. Thank you for your time and your attention.
Thank you, Councilman. Mr. Andrews, since there wasn't any of the cross-appeal addressed in that response, there's nothing to rebut, so there's no rebuttal. We thank you all for your arguments. Court's in recess.